Good afternoon and welcome to the collaborative webinar being delivered in conjunction with Beale & Co, ACE, and WK Corporate Finance. My name is Nelson Ogunshakin, and I'm the CEO of ACE. I see the list of those registered are quite diverse, so it's exciting to see so many people register for this particular program. Hopefully some of the coverage will be very useful to a lot of them. We have on our program quite an interesting agenda. The background to the particular webinar is we have seen quite a lot of merger and acquisition. We've seen a lot of economic growth in the industry. And as a result of that, it was appropriate that this particular webinar is quite timely. The program will spread over the next 3 months. Today we'll be dealing with growth strategy about buying. We also hope to address the issue of selling the business. That will be on the 9th of December. And in January 2016, we'll be looking at post-merger integration. Key message really is what is the benefit? The conversation will be addressing strategic issue. It will address financial issue and will also address legal issue. Without further ado, for today's particular program, I'm really privileged to have a lot of eminent people to support me. I did introduce myself as the CEO of the ACE, and it's an organization that's 500 by size of membership, employing 90,000 and a turnover of nearly 9 billion. Joining me today is Dan Nixon from Partner, which is Head of Transaction Support, WK Corporate Finance, in a minute. Likewise, I've got James Hutchinson from Beale & Co, a partner who will be looking at the legal aspect. We're also privileged to have Dwight Patton, ACE Legal Director, who will be looking at the question and answer as we move through the whole of the conversation today. There will be opportunity at the interface between 2-3 speakers for question and answer to come through. We do everything we can to try and address as many as possible questions. But if for any reason we're unable to cover all the questions, there will be a further opportunity to pick that up. So if I take the very first part of the program for today, is looking at issue about corporate responding to market drivers. We know for sure that growth is something that is healthy for every company. Not only does it create challenge, but it creates opportunity for people to join company, but also is quite healthy in any business to make sure that at least the company is going in the right direction. So what are the options for growth? I've put 3 propositions. One is to build internally. The other one is borrow, and that could be in the form of alliances, collaboration. And for companies who are probably small, medium, or large, they will approach it in a different way. That could be across in a regional dimension, or actually country by country. Or there is also opportunity for strategic growth through sector, and that could be project by project or individual sector. One of the key areas which is becoming very popular and increasingly being visible and more people talked about it is the issue about merger and acquisition. And the big issue there is very much one about strategic fit, i.e. how do you intend to grow your business in such a way that by true merger and acquisition you can derive the benefit you wanted. What I intend to do is to consider all the options available and very quickly go through what I call the pathway framework that allow individual company, regardless of where they are, whether they are small, medium, large firm, are able to exercise discretion as to what strategic option is open to them. If I start by looking at what I call the resources pathway framework, and it's a model that is open up to quite a lot of companies, and you don't have to be very, very big, and you don't have to be very, very small, but it's looking at the options between whether you have an internal growth or you go for acquisition. The journey between internal growth, which is organic, and acquisition has a number of options. So on one side of the slide, you look at the strategic resources gap, which are the options open up. And what I've actually tried to outline in the other side is looking at the question that needs to be asked in terms of knowledge base require, an issue to do with governance, and more important to look at what are the options available. So if we start with build, which is really internal resources relevant, it's quite obvious that if you look at knowledge question, is one about you have strong knowledge fit because you are building within the same culture. And the governance is actually quite strong because you are expanding existing corporate culture that is very much in. So that tends to work very well along the line of our internal growth. The question you need to ask when you start looking at borrow is effectively asking the question, how do you look at the resources as best as you can, and how do you match the resources with the issue of what you need in your business? So there is a requirement for high resource clarity, which is be absolutely sure what you need. There is also high resource, protection. Because if you are in partnership with a company, there's a tendency not to have 100%, open arm on some of the company secret and company ideas or intellectual property. To that end, the structure of that relationship tends to be on contract and a contract basis. The other option that comes across is borrow via alliances. Um, this desire closeness with resources partner. We have seen increasing number of that more on project, not only in UK but also on a global basis where resources is pretty important. But this actually requires narrow collaboration in terms of scope of work. But there's also the issue to do with compatibility of partners, which is, do you share the same goals? Do you have the same strategic aim? And do you have the same strategic objectives? With that in mind, you're effectively looking at issue about alliancing. And of course, in that alliancing, there is issue to do with contract. So contract needs to be formulated. The final option that we have, which is really about buying, and my colleague will be talking about that later on. What does it mean? What is critical there is a feasibility of target firm. It's absolutely important that before you go into the idea of buying a company, you have a clear integration map, which is not just about identifying the company, but also seeing how the company will fit in. And that is very important because one of the things that come through in M&A is all about synergy. And that could be synergy in terms of, sector focus. It could be synergy in terms of resources. It could be synergy in terms of efficiency. So it is absolutely important that a clear integration map is already in place well in advance of the process of acquisition. There is issue about high employee motivation, not only on your existing employee, but also the employee to be acquired. So that looks at the issue about acquisition from that standpoint. The challenge for any company who wish to go along that line is don't do M&A for the sake of an M&A. And one of the things that I thought was absolutely important is to address what are the drivers for M&A in the market. It's quite obvious that we've seen a lot of large firms coming together, which means people are coming together purely because they see bigger company can address bigger projects. And to some extent, there's a view that, bigger company is being decided because clients want bigger business decision-making process. The other challenge that we have, which is a driver, is the issue about availability of private equity company. There's a lot of funding that is floating around looking for good home. We know for sure in the consultants and engineering and perhaps to some extent in construction industry that the return in our sector is not that too bad. So the availability of funding is very, very critical. The other issue that comes to play is the issue of value arbitrage, which is the way you value your company as a private ownership compared to valuing your company as a public ownership. That actually creates an opportunity for M&A. On the other hand, you look at the issue about globalization. A lot of companies, we've seen that they've grown because the global demand on their resources, and so globalization leads to consolidation. We've seen quite a lot of companies more recently, without mentioning few names, who foresee that the ability of having global resources is critical to their success. So globalization tends to encourage consolidation. Other factor, which is a major driver, and one need to acknowledge, is the availability of cash surplus in major blue chip company who are looking for good home, and then the driver for return on investment becomes a real challenge. Other areas of interest which actually cause in M&A is the pursuit of what I call the hot areas. So the hot area could be hot countries such as Middle East, or it could be hot sectors such as sports sector. And we've seen a lot of that in terms of the Olympic, or it could be hot area in terms of energy. So that's an area where it's causing a lot of interest in the marketplace. There is also other school of thought that says, people and companies with very good M&A, they've perfected the art of M&A, and therefore, one of the key strategic growth area for them is about M&A. I've always argued the case that international platform is international platform is very, very important for companies who are seeking to diversify their business portfolio, and as a result of that, I think M&A tend to become an opportunity for growth. And finally, there's the issue about mergers of equal, which is company of the same size, of the same ilk, but different geographical area, but have the same particular interest, and coming together, 2 plus 2 perceived to be an opportunity of being 5. And that can be a driver for M&A in the marketplace. On that note, I think that set the scene in terms of where I'm coming from as an introduction to the particular topic. My colleague Dan will come in a bit, but I think I'm going to pass it on a little bit at the moment to Dwight to see if there's any question coming across from the floor.
Thanks, Nelson. Before I pass over to Dan, yeah, we do have a few questions coming in. Sorry, just sorting out the mic. Yeah, thanks. So there seems to be a lot of interest around, well, okay, you've set up these 3 routes for growth, and how do I go about deciding which strategy to take? In particular, how do I decide if the organic growth route or the M&A route is the best one for my company?
I think in any growth strategy, you do need cash. Cash is king. The decision as to whether you go for organic growth or you go for M&A boils down to a very simple issue. Organic growth takes quite a long time to effect, but as I've demonstrated in my previous slide, you have a better synergy through organic growth because you have the culture and you can actually grow that in a sustainable way. The decision to go for M&A is one about how quickly do you want to achieve your strategic intent. If the intention is to try and achieve that over a short period because you are in a very rapidly growing market, then you have to make that decision. But either organic or M&A, evidence suggests that companies which are successful in the marketplace combine the two together.
Thanks, Nelson. And just a little bit more on when it's appropriate to consider adopting a strategic alliance or joint venture growth strategy.
The strategic alliance side is very simple. I think it's very much if you take a domestic market where it comes down to resources or complementarity in terms of skill base, then the challenge to look for a partner who complement what you bring to the table. And because you are looking at it purely from project by project basis or country by country basis or sector by sector basis, if you do not wish to go into the M&A and you want to dip your feet in the water and test, so alliances and partnering are the right strategy to pursue. And we've seen that happening effectively on major projects where the skill sets are complementary and allows risk sharing, and also give opportunity for various parties to get to know each other before they decide to move to the next step.
Brilliant. Thanks very much. That's a lot to think about on the strategic side. We're going to hand over now to Dan Nixon, who is going to say a little bit about the financial considerations. Over to you, Dan.
Thank you, Dwight. Good afternoon, everyone, and welcome to this short presentation on finding and valuing a target by me, Dan Nixon. So a bit of background on me. I'm partner of a top 20 accountancy firm, Wilkins Kennedy, and director of corporate finance. I'm a qualified ACA accountant having been working in corporate finance for more than 9 years, and have advised on 80 plus completed transactions. Bit of background about my firm, WK Corporate Finance. It's a wholly owned subsidiary of Wilkins Kennedy, multi-locations in the southeast of London. We offer a complete range of corporate finance services in the SME space to private clients as well as institutional funders. We specialise in lead advisory and transaction support services, advising clients on all aspects of the deal from start to completion, and typical transaction values are in the £2 to £50 million range. We've advised in a wide variety of industries, including the construction, property and engineering sectors. The strength of our relationship with funders is demonstrated by our track record of completions. More details are available on our website if you're interested to know more. I'll now go on to talk about finding and valuing the target. The three areas I'm going to consider are identifying the target, valuing the target, and financing a deal. So first up, how to identify the target. To identify the target, you first need to consider the current opportunities for growth in your sector. So taking Nelson's three core corporate options of build, borrow, and merge or acquire, you've chosen to grow by merger or acquisition. And this might be because the sector is in a growth phase and you wish to aggressively build your market share, or it could be because the sector is very fragmented and there is an opportunity to consolidate. So having considered acquisition as the way forward, you need to decide what your objectives of undertaking an acquisition are. Some of these already touched upon by Nelson. It could be business certainty, securing costs and the supply chain via vertical integration, or absorbing the competition. It could be to increase scale, driving cost savings, improving purchasing power, and strengthening the balance sheet. It could be to diversify your service offering, the acquisition of a company offering a complementary service that would broaden the current offering and move the company towards a one-stop shop. It could be to increase your geographical footprint, the acquisition of a competitor in parts of the country not currently serviced, or it could be to fill a skills gap or resource gap in the management team. Having defined the reasons for acquiring, you are now much clearer on the characteristics of your perfect target. So next, you should set parameters based on these characteristics. The business type, is it the same sector or is it different? The location, what radius in miles is the target for the business? The size, consider turnover and profitability in comparison to your business. Are there capacity restrictions to consider for the enlarged group? And finally, price. Whilst you may not have yet considered the funding possibilities in detail, which I come onto later in my slides, some rough idea of what a realistic maximum price would be should be considered. Finally, to conduct the search for a target, utilise the company's house website, which contains annual accounts for all registered companies, to do some background research. Use other resources available, such as industry contacts, search engines, and professional advisors to identify companies that fit the criteria. Perhaps make the market aware of the acquisition criteria by engaging a corporate finance advisor to approach contacts or targets direct on a confidential basis. So having discussed how to identify and find the target, I'll now discuss how to value the target. Firstly, it would be remiss of me not to say that the true value of a business is what a willing buyer will pay a willing seller. Therefore, how does this price get established in the first place? There are common methods of valuing a business. Some examples are net assets. This is generally not considered an accurate basis for a going concern, but if the balance sheet figures are shown at or close to their market value, then it can be a useful indication of an underlying base valuation. The dividend yield method is generally a method used to value a minority interest and seeks to interpret the return available to the minority investor as being the stream of dividends received from the company over a period of time. The discounted cash flow basis is arguably the most complex method, but where it can be applied will give the best guide to economic value of a target. It attempts to provide a valuation of the future cash benefits projected to arise as a result of the acquisition, and is achieved by way of discounting the estimated future cash returns. It does require medium to long-term future cash forecasts and a number of robust assumptions to enable an estimation of the ultimate residual value of the shares. Capitalized earnings basis is applicable to valuing a business as a whole and is a well-used and generally accepted valuation model. It takes a level of earnings representative of the business and applies a multiple. This multiple may be determined by referencing comparable companies, normally obtained by dividing their market value by their earnings, where the market value is information that is available, and unsurprisingly, comparable companies are usually equivalent quoted companies. And after adjusting for perceived differences, an appropriate price earnings multiple, PE, is then arrived at to be applied to the earnings of the target to calculate your valuation. So now you have looked at the various valuation methods above and run some calculations. You should consider which method best reflects the value of the target to you. Valuations, in my experience, are typically based on reported historic financial performance using the capitalized earnings basis. We generally apply a multiple to EBITDA, earnings before interest, tax, and depreciation. This then gives the enterprise value of the company. The appropriate multiple is derived from sector averages and can be impacted positively and negatively dependent on security of future revenue and performance, amongst other factors. And the equity value of the business, value of the shares, is the enterprise value less debt plus non-core assets plus cash that will be acquired upon purchase. So looking next, you need to determine an appropriate valuation range. The headline valuation will provide a figure that values the company as it stands. A valuation range can be arrived at based on the value to you as the purchaser. There may be potential synergies to consider, such as combining HQ, finance teams, or other central infrastructure, which would make the acquisition more desirable and would allow room to pay more upfront and potentially still get a good deal. Management team expertise from acquisition. Could this have the added benefits of the current business? Conversely, if the management team are leaving, are these fundamental to the business and would a lower valuation be appropriate? Use due diligence to firm up on your valuation of the business. James Hutchinson, who's up next, will be touching upon the due diligence process in more detail during his presentation. So having considered how to identify and find the target, and then undertake to value the target, I will now finish by considering potential sources of finance for the acquisition. First up, cash in bank. This is a topic that Nelson picked up in his Q&A just now. This is the simplest source of finance for an acquisition. However, you should consider the opportunity cost of not having that cash in the bank. Some key considerations would be, is the business seasonal? Does it rely on having a meaningful level of cash on the balance sheet during cash positive months to fund cash negative months? Are there any short-term cash requirements, for example, CapEx, capital expenditure? Is there enough to leave a buffer to safeguard the business in a potential downturn? Are there other investment opportunities that will generate a comparable or even better anticipated return than the acquisition? Another source is debt funding. This is typically the cheapest form of funding available. Although the funding tends to be secured via a charge over the company's assets with financial covenants that require ongoing monitoring and management. In the last 7 years, debt funding has been less available, and particularly in relation to smaller acquisitions, which is why we have seen more transactions with vendor loans. A vendor loan is debt funding provided by the seller of a business. In this instance, the seller steps into the shoes of the bank, foregoing cash today for cash tomorrow. Other options include mezzanine funding and equity funding. Mezzanine funding is funding that typically takes the form of debt. It is subordinated to the debt, provided by senior lenders such as banks and private equity. There are lesser covenants in place, however it tends to carry a higher interest than a bank, and a small, often preferred equity stake is also typical, normally less than 10%. And finally, equity funding is funding in the form of share capital. Typically, equity investment will have no covenants. It could be in the form of a private equity investment, a public offering, or a private investment. In the case of an acquisition, it may be appropriate to incentivize the shareholders of the business you're acquiring by offering them shares in your business. Interestingly, a growing trend we have seen at WK is for owner-managers to take on private equity investment to grow by acquisition, whilst at the same time taking some money off the table, therefore de-risking. So what is apparent, having considered cash, debt, mezz and equity funding, is that the general availability of finance is a definite consideration when valuing a target, as this determines affordability. This brings me to the end of my section. Thank you for listening, and if you have any questions arising, please either contact us via the webinar or follow up using my contact details on screen.
Thanks, Dan. Yeah, we had a few questions in. Before I go through those, just want to remind all the listeners that if you want to ask questions, you want to use the toolbar on the right-hand side of your screen. So please go ahead and send those questions in. Dan, one thing listeners are interested in is how much does it typically cost to undertake an acquisition?
Thank you, Dwight. This is an interesting question, because the natural thing to do when someone asks you this question is to focus on the financial costs. But to answer that, it does depend to some extent on the size of the transaction and the types of funding being sought. There'll be professional advisor fees, DD fees, arrangement fees. It's not a cheap exercise by no stretch of the imagination. From experience, these can amount to as much as 10% typically of the transaction value, where there is debt and equity being raised. What I would say is that as equal importance is the non-financial costs. And specifically, I would refer to the time that it takes for senior management to engage in the process, not just before, as part of due diligence and as part of just liaising with their advisors in order to get the deal done, but also after the transaction and part of the integration process.
What sort of time frame are we talking about there, Dan?
In relation to the transaction from beginning to end?
Yeah.
So it can sometimes be dictated by the company that you're acquiring. However, we would typically say a transaction up to completion could be concluded within 3 months from start to finish.
Okay, it's useful to know what you're looking at in terms of planning. Just one more thing. What do you think is driving this trend of private equity investment you're seeing in the SME space at the moment?
Yeah, so this is certainly something that is a trend, a growing trend, and has been since 2008, from when the banks became less active in the SME space particularly. And as a result, there have been fundamentally strong businesses looking to raise finance for acquisitions or for MBOs, and private equity have stepped into this market to get deals done, and they've created a track record now, which is investing in the SME space, which is therefore attracting more money to that space. And a good example of that would be the Business Growth Fund, which was created 2 or 3 years ago and has been investing equity into the SME space in chunks of 2 to 10 million, and they've come into a market trying to do volume, which historically hasn't necessarily seen volume from one single player.
Oh, okay, I wonder if maybe we can provide some more information about that fund after the webinar.
Yeah, I'll be very, very happy to.
Great. Okay, we've had a strategic overview from Nelson, and we've had a good look at some of the financial considerations. We're going to hand over now to James Hutchinson of Beale & Co. To look at the legal considerations. Over to you, James.
Thanks very much, Dwight. Hi, I'm James Hutchinson, a partner in the corporate team of Beale & Company. Dan discussed how you identify a target and value it. I'm going to look at today the legal process of buying that business and ensuring that you do lock in the value that you want. My talk's going to cover four main areas: the legal structure of an M&A deal, so why you might go for a share purchase versus an asset purchase, and the factors influencing that deal structure. I'm going to look at the due diligence process itself, so the extent of due diligence, and financial and legal due diligence. I'm then going to turn to the key legal documentation on an acquisition, such as the heads of terms, the heads of agreement, the share purchase agreement, and the disclosure letter. And then I'm going to look at how to protect the buyer's position and the value you've put on the business by structuring the consideration payable to the sellers and through the use of warranties and indemnities. So, starting with legal structure, where a target business is carried on by a company, there are usually two ways of acquiring that business. The first is by share purchase. This involves you acquiring the shares of the company that owns the target business or assets. And the second is a business or asset purchase. And in this alternative approach, you simply buy each of the individual assets that make up the target business. There's a fundamental difference between the two deal structures. When you buy shares in a company, all its assets, liabilities, and obligations are acquired, even those you don't know about. If assets are purchased, only the identified assets and liabilities that you agree to purchase are acquired. So on a share purchase, shares are transferred to you by means of a stock transfer form, where assets are changing hands. Where you have a business purchase, those assets need to be individually identified and transferred. So there's a number of key factors which influence structure. The first of these is liabilities. Sellers will often prefer to transfer the company or group of companies lock, stock and barrel by way of a share purchase. This is because the seller's ongoing liability will be limited to the extent of any warranties and indemnities they've negotiated with you. But by contrast, many buyers prefer an asset purchase, especially if they're concerned about particular liabilities in the target business, and if they would prefer to cherry pick the assets they want to transfer. Tax can also have a big role in influencing structure. Parties probably have different objectives, and it's unlikely that these can all be met within the same structure. We don't have really time today to go into all the tax implications, but very generally speaking, the tax advantage of a share purchase to the seller are likely to be greater than the tax advantages of a share purchase to the buyer. Conversely, an asset purchase will often be more tax efficient for the buyer rather than the seller. However, there were some changes introduced in the July 2015 budget, which means that tax advantages of an asset purchase for the buyer are now likely to be reduced. As always, it's important to get advice and to look at the particular circumstances of each deal. Where there's a partial sale, for example, the sale of a division of the seller's business, it may be more practical to structure the transaction as an asset purchase. Otherwise, it will be necessary first to set up a new company and to transfer, or what's called hive off, the relevant division to that company, following which the shares in the company can be acquired. And finally, consents. Where third-party consents are required to transfer assets, and it's impractical or thought to be impossible to obtain all those necessary consents, for example from individual clients, a share purchase might be the only way of practically acquiring the target business. So, turning to due diligence. Due diligence is the information gathering process carried out by you to find out as much as possible about the target company. This should start at the outset of negotiations, so it's really something to kick off right at the beginning. Through the process, the aim is to gain as much of a complete picture as possible of the target and its critical success factors, strengths and weaknesses. It's an essential preliminary to contractual protection and can help identify the extent of protection you actually need and any risks that you might just want to completely avoid. Information obtained through due diligence will help you decide whether you want to proceed with the acquisition, and if so, at what price and on what terms. DD can also help you plan the integration of the business and identify any third-party consents and other documents you need. We're going to deal with integration in the third of our webinar series, which takes place in January. Because the greater risk assumed by buyers of shares, the level of due diligence required on a share purchase will usually be more than an asset purchase. The focus of the legal DD will depend on the nature of the company being acquired. So, for example, if you're looking to acquire, say, a consulting engineer, you should spend a significant amount of time combing through their appointments. The DD exercise generally comprises an assessment of the financial, legal and commercial status of the target. It's typically carried out, as Dan mentioned, by your financial and legal advisors in conjunction with your own employees. Dan touched on financial DD and how it focuses on those areas of the target business that are material to your decision to buy. Financial DD will usually lead the whole process and factors into the valuation mechanism by looking at historic accounts. Historically, accountants and solicitors have approached their respective parts of DD in slightly different ways. Accountants inspect the working papers of the seller's accountants and have lengthy discussions with the target company's management and its accountants. Legal DD tends to be carried out in a more remote fashion. The usual pattern of events is for your solicitors to send a questionnaire to the sellers requesting information on a wide range of matters such as the target's tax position, commercial contracts, and maybe the status of things like intellectual property in the business. The sellers then collate the information and documentation requested and pass it to your solicitors, who analyse it and report on their findings. The results of the legal due diligence exercise can and should assist in drafting appropriate warranties to cover specific situations. It's often the case, however, that a first draft of the share purchase agreement to be circulated before the legal DD is completed. If so, the buyer's solicitors should make clear that further warranties may be required when the legal DD has been completed. Although DD is an important fact-finding exercise, it's only as good as the seller's cooperation. The seller may have doubts about the buyer's intention or may be reluctant to disclose sensitive information to a competitor just in case the deal falls through. Obviously, if the seller wishes to succeed in selling the target, it has every incentive to cooperate, but just as a matter of law, there is no general obligation for them to assist with DD inquiries. So there's a number of key documents which will be prepared as part of the transaction. The first one that you usually come across is the heads of agreements, or also called the heads of terms. And these are entered into between the sellers and the prospective buyer. Purpose is to outline the main terms of the proposed deal between the parties and to provide a structured basis for negotiating formal documentation relating to the transaction. Heads are usually entered into at the beginning of the transaction process before the parties commence a lot of DD and before they incur significant transaction costs. In the case of an asset purchase, the asset purchase agreement is usually the main contractual document which affects the transfer of the assets from the sellers to the buyer, and in a share purchase, the share purchase agreement is the principal contractual document. In both cases, depending on the complexity and size of the particular acquisition, the agreement can often run to more than 100 pages, with as many as half of these comprising warranties. As well as containing lengthy warranties and indemnities, the agreements deal with how the consideration is to be satisfied, what conditions precedent the purchase will be subject to, and restrictive covenants which bind the parties. On a share purchase, the SPA will also usually include a tax deed, also known as a tax covenant, where the sellers agree to indemnify you against various tax liabilities arising prior to the sale. It's usually only relevant to a share purchase as on a business purchase, the buyer doesn't usually assume the selling entity's tax history. Looking at the SPA, on most acquisitions, the seller will also prepare a disclosure letter that contains both general and specific disclosures against the warranties contained in the acquisition agreement. Warranties and disclosures must be considered together. If a warranted fact turns out to be untrue, the buyer will usually have a claim for breach of warranty, a breach of contract, regardless of whether they relied on the warranty in question. However, no claim will lie if the facts which give rise to the breach were disclosed in the disclosure letter. It's therefore a key transaction document and is usually heavily negotiated between the parties. Other key documents which might be relevant are things like exclusivity agreements restricting the rights for the sellers to speak to third parties, and contribution agreements which apportion liability amongst the sellers. So when you've found your target and you've got partway through the SPA and negotiation, one of the important things to do is obviously to protect your buyer's position. And there are various ways to do that. In my view, one of the most important is the structure of the consideration. Unless there's a particular reason for doing so, I'd never advise on usually paying 100% of the consideration in cash on completion, and that would be pretty rare these days. You can protect your position in a number of ways by deferring the consideration and the use of price adjustment mechanisms. For example, by preparing completion accounts which seek to link the price paid to the actual financial position of the business at completion, or through the use of mechanisms such as an earn-out, where the sellers only receive tranches of consideration based on post-completion performance. I'll focus on these mechanisms in greater detail in our next webinar in December, which is aimed at the sellers of businesses. Another means of protection, as we've mentioned before, is the use of warranties. These are contractual statements, usually contained in the acquisition agreement, as to the condition of the target company or business. A thorough due diligence exercise should provide you with a good picture of the value of the target company or business. Warranties are not a substitute for due diligence. The two are complementary. It's always preferable that you know in advance about a problem, as you then have the opportunity to terminate negotiations, seek a price adjustment, or seek specific contractual protection, rather than just then having in the back of your mind the right to sue for a breach of warranty. Really, warranties serve two purposes. They provide you with a remedy, also known as a claim for breach of warranty, if the statements made about the business later prove to be incorrect and the value of the business is thereby reduced. So really, they're a kind of retrospective price adjustment. And secondly, they encourage the sellers to disclose known problems to you. Because the seller's liability under the warranties is usually limited to the extent that proper disclosure is made against them, the effect of the warranties should be to flush out potential problems. And finally, indemnities. They're really the strongest form of contractual protection. An indemnity is a promise to reimburse you in respect of a particular type of liability should it arise. The purpose of an indemnity is to shift the risk of a particular event or matter to the sellers and to allow you to recover on a pound-for-pound basis in respect of that event. Indemnities are often used where a warranty might not allow you to recover. For example, because you had knowledge of the matter before signing the agreement. That's really everything I wanted to say today. Obviously, if you've got any questions for me, you can pose them via Dwight or to contact me direct. So I'll just hand over for a moment to Dwight.
Thank you, James. Actually, one of the questions come in I really recognize from my time in private practice. It's, why is this transaction taking so long? Really interested in understanding what kind of legal issues can cause delay in the transaction. You know, if we're looking at trying to get this all over and done with in about 3 months.
Everything and anything can come up, often things out of due diligence. In my experience, one of the main issues is the negotiation of warranties and indemnities. And sometimes on either side, you get a very entranced position from a kind of buyer's position or seller's position. my view is when I'm drafting warranties to go into a share purchase agreement, to reduce the amount of time negotiating them is to take a balanced approach from day one. Who is best able to bear the risk arising from those warranties? I don't see much point from a buyer's position in including dozens of irrelevant warranties, sort of standard warranties you might get from the textbooks. It's far better, and the buyer is far better served by having tailored warranties which are actually connected and relevant to the due diligence and the type of business, because actually that's more relevant to the buyer and the risk, and also helps to reduce the amount of time and delay that can creep into an acquisition as part of the negotiations. The second sort of legal issue which can cause delay, it's a legal and commercial issue, is often in relation to the individual terms that sellers receive. So if the sellers are remaining in your business and will be entering into employment contracts or have bonuses, etc., often these things are left towards the end of the transaction to actually formally negotiate, and far better to deal with them at the beginning, because actually very minimal and very what might be seen as small changes to their terms post completion, they sometimes take them very personally, quite reasonably, and that actually can delay the transaction going ahead.
So with some careful planning, you can probably spot those kind of issues at an early stage and start to deal with them.
That's right.
The other thing is we go through this process of due diligence, and we get a really good idea about what we're buying. But I suppose occasionally something does go wrong despite all of that, and you have to make if you're a buyer, you make a warranty claim against the sellers. How do you go about making a warranty claim when the sellers are now part of your business?
Yeah, that's an incredibly difficult thing to do. You always have the right to do so, but if they're staying in your business and if they're people you want to keep in your business and integrate and keep working with, the risk is that by doing so you can destroy value. You have to look at the best ways to protect that. And again, I think it's something to deal with at the beginning of the transaction as much as possible, about how you structure the consideration. So you're able to deduct, say, future consideration. So you're able to deduct a warranty claim from consideration that's still to be paid, rather than going to your employees or senior staff and saying, well, actually, I want some of that money back. That's always particularly difficult. I also think it's very useful but rarely done is to include what's called ADR, alternative dispute resolution provisions, in the SPA or asset purchase agreement, and that can put in place a procedure whereby if there is a dispute, parties don't just run off to court, but you, as you often see in construction contracts, you might enter into a mediation or have some other method for formally resolving disputes. However, in some circumstances, and we have seen this and we have done it, it is sometimes necessary to bring a warranty claim, and you do that going through the courts, but you need to be very sure that when bringing that claim, you're able to demonstrate that the value of the business as a whole has been reduced to less than you've paid, not because otherwise you won't be able to bring a warranty claim. It's not that just you're lost one single asset when actually the overall value of the business is the same.
Thanks, James. That's all very helpful. We've got we got a little bit of time for questions. We've got one interesting one, which I think is partly for Nelson, and then I think he might just briefly hand back to you, James. It's an SME-based question. It's really, are there strategies which are more commonly utilized for SMEs? And if so, can you advise? Nelson, over to you.
Thinking in terms of strategies which are relevant for SME, it's very, very difficult to actually be too prescriptive as to what is the perfect solution. For SME company, I think the both option in terms of whether organic or acquisition are open. I think SME will probably consider a bolt-on acquisition which is a very small group as you start to expand your business. But as time goes on, it may be a bigger acquisition. But I think from this standpoint, most of the recommendation for SME is very much on organic approach. There are opportunities where if it's a consulting firm where you start in one particular discipline and you wish to become multidiscipline, then one of the way of going forward is looking at a package or an entity which gives you a complementary skill set. And that could be a team of 5 or 6 or 10 or even 20 or 30 or 40 that actually bring complementarity to the business, and that allows you to move forward. How you structure that, as James talked about earlier on, depending on whether it's a cash payment or whether it's actually going to be an issue about earn out. But I think that option is open to individual. So both organic and acquisition is open to SME, but predominantly a lot of the SME goes for organic approach. Where the opportunity for collaboration is available, they should always consider that.
Thanks, Nelson. I'd just ask you to hand over to James briefly. And James, I wonder if you could comment on that question from the point of view of the structure of the transaction, legal structure.
Yeah, could you just repeat part of the...
Yes. So it's from the point of view of SMEs, are there strategies which are more commonly utilized?
Keeping the transaction as simple as possible. There's not much point incurring massive legal costs drafting vast share purchase agreements where, for example, the risk on the transaction is relatively low. So if you have a small business and you're buying a similar small business and you know a lot about their business and understand the risks that are likely to be incurred, you can probably narrow down the warranties to those issues that are of particular concern to you. And that is usually the simplest way of doing it, and having short form agreements and getting the deal done as quickly as possible.
Brilliant, James. That sounds practical. If you didn't mind just handing back to Nelson, I'm going to hand over to Nelson to do a few final words for us on the growth strategy. Thanks a lot.
Well, I think having listened to the three speakers, including myself, I think it's given us some food for thought. In any growth strategy, it's always very important to have a roadmap. And this sort of, point that I'm going to flash out is really just trying to ask the fundamental question. In summary, just for today, I think I'll be looking at the issue of internal capability analysis is very, very important before you venture into M&A, that you do a proper gap analysis. That is very critical to see where you are, where you want to be, and what is the gap, and therefore it helps you in identifying target. That's extremely important. Strategic objective is very critical. A lot of people goes into the M&A by accident without any clear focus or strategic intent. So it's extremely important that you have a clear focus on the needs. Sometimes people move into M&A accidentally, and then it becomes a major issue in actually trying to address that. So it has to be a strategic objective, clearly stated, clearly focused, and understanding the needs, and that helps with the roadmap. Obviously, going forward, once that strategic intent has already been decided and the board approved it, then identification of targets, as Dan said earlier on, is quite critical. And I use the word target here. It could be a target at regional level, at country level, at sector level, or even the clientele that you want to target. It's extremely important because all of that come into the equation as deciding what sort of company you're looking for. Other point that is absolutely critical is the issue about due diligence process. A lot of people ask the question, is it important? Yes, it is critical. Because it helps you to establish the strategic fits. There is no quick way in it. It would not address 100% all the question, but it gives you a flavor, and it actually pick up on all the key issues to allow you to move forward. Valuation of the enterprise is critical. I think Dan talked about various means of valuation. Market value plus synergy is a key word that I tend to use. And the key challenge is, how do you value synergy? That comes down into your own interpretation of where the fit will be, whether it's synergy in terms of our ability to work with different clients, to do cross-selling, or synergy in terms of operational efficiency. All those issues are pretty critical, and that comes as part of the process you have to go through in your due diligence process. Deal negotiation is very critical. I will always caution against bidding. If you are not prepared for it and you don't have a strategic fit, or you feel what you had in mind is being awaited, avoid bidding wherever you can. Because sometimes when you've already crystallized how much you're prepared to pay for the transaction, that get blown off because of the forensic of bidding. So wherever you can, avoid it. Transaction management is very critical. Yes, you may think it's very expensive, but it is critical. And having a proper structure in an organization that deals with transactions of this nature, because you have a one-point sense of ownership and one-point sense of responsibility and accountability. That's very, very important. Stakeholders engagement. We can talk about merger and acquisition. We can talk about whether it's organic or different. Stakeholder engagement is extremely critical, and that starts from your staff, their clients, and all those people who are involved with the particular project that you need to look at. We've seen a lot of transactions that's happened that actually end up with a major, what I call, asset loss because of lack of engagement with stakeholder. In the consulting sector, which is the bulk of what we're talking about, people are very critical. So carrying your staff along and carrying the staff of the acquired company along is extremely important in the process of that. Of course, we are going to talk about merger and acquisition. In the next phase, we'll probably talk about the issue of post-merger integration. The critical point is really the PMI is very important. A lot of the synergies that you anticipated in your target and the valuation you put into the process, that comes into fruition through the PMI. And we'll be talking about that, I believe, in January. On the basis of that, I'm quite at this stage to say it's been a pleasure to share the platform with my colleague, Dan and James. I hope the audience really had some food for thought on some of the consideration. The next session is coming up, which will be in November, if I've got the date right. It's targeted towards November, I think if I've got it, December 9th. We'll be talking about selling the business. And again, the three speakers that we had today will cover exactly the same subject, but in a slightly different angle. And finally, we'll be looking at post-merger integration, and that'll be coming up in January. On that note, it's been a pleasure. Thank you very much, Khalid, for joining me, and I hope you find the conversation very useful. Thank you.